Good afternoon, everybody, and welcome to this afternoon's session regarding the Ethics Masterclass. It brings me great pleasure to introduce our speakers this afternoon. Michael McGarvie, who we all know as Commissioner and CEO of Legal Services Board and has been so since January 2010. Formerly, he was the CEO of the Supreme Court of Victoria. He held that position for a period of 3 years. And for the bulk of his career was a partner at Holding Redlich. So I'd like to welcome Michael here today. In addition, we have Angela Barrick, who is also an employee of the Office of Legal Services. She's a complaints officer and solicitor, and she spent the last decade in legal regulation. Sounds a long time now, doesn't it? I'd also like to welcome Sarah Lethlean, who is also at the Office of the Legal Services Commissioner. She works as a complaints officer and is a solicitor. Sarah is a former in-house TAC lawyer, where she spent the last, that would also be a decade, wouldn't it, Sarah? Yeah, and Sarah is a former colleague of mine too, so I'd like to welcome Sarah here today. So without any further ado, I'd like to introduce Michael McGarvie to prepare and present his presentation. Thank you, Michael.
Well, thank you very much, Stuart. I thought I might go through a few formalities to informalise the presentation. I've asked Stuart to insist that people come as far down the front as possible, and we're not being discourteous in sitting down. I hope that doesn't prevent the voice from being projected to the back of the room. The reason why we wanted to sit and present this way is because we expect each other to interrupt each other while we talk, and we would invite you also to ask questions or prompt ideas or suggestions or comments as we go. We'll endeavour to leave plenty of time for questions if that's necessary, but at this sort of position, are people who are sitting down the back able to hear me speak? Is the sound going back? We'll try and project as well as we can. Thank you very much, Stuart. You've had an introduction to Angela and Sarah, and I see these sorts of presentations as pretty important because they provide me with an opportunity to... There's seats down the front, gentlemen, and I'd love it if you occupied those front seats. The opportunity to go back into the law firms that are so important to regulation. Good regulation is about decent relationships. We operate out of 2 floors of 330 Collins Street, but because I am familiar with law firms, because I was a solicitor and a partner at Holding Redlich for 23 years, 18 of which I was a partner, I feel as if I want to use my familiarity with the pressures on lawyers and the issues that affect legal services to be a better regulator. So much of the themes that we'll concentrate on today are about communication and managing expectations to deal with ethical issues and to minimise the prospect of complaints being made against you. And that's the sort of the approach that we take as well as a regulator. We must communicate very thoroughly with those 16,000 practitioners we regulate, and that involves getting out to the places where they work and understanding a lot about the pressures on them. I actually am CEO of both the board and I'm Legal Services Commissioner, and structurally they're 2 regulatory institutions. We work very hard to make them look like one, but we don't always succeed. The board deals with aspects of regulation that are not complaints about conduct or costs. They deal with that. They run a registry that registers all of your details and your registration and certification history. We share with the Law Institute and the Bar the supervision of trust accounts and the inspection of trust accounts, and the theme of trust account inspections and conduct issues and ethical issues emerging as a result of trust account inspections will emerge in our discussion later today. The board manages a fidelity fund, which is a compensation fund designed, it's your clients' the interest that your clients would have otherwise earned from money placed into trust accounts that funds our operation and funds a fidelity fund and a public purpose fund that contributes much to, for example, community legal centres and other academic research papers and employed people in the area of legal activity that doesn't normally get funding. But the Fidelity Fund is a compensation fund designed to compensate clients of a lawyer for financial loss as a result of the fraud or dishonesty of their lawyer. We manage the $1 billion of funds that we are responsible for that support that represent the public purpose fund and the Fidelity Fund, and the interest earned from that funds our operations. We deal with receivership, so if we apply to the Supreme Court to place a practice into receivership, if there are certain conduct issues or trust management, financial management issues that cause concern, we give and take away certificates. We give out about 16,000 every year, and we share that role with the LIV and the bar. In fact, the LIV mainly handles the certificate renewal process for solicitors, and the bar does entirely for barristers. The board looks at suitability issues, so whether a person is a fit and proper person to hold on to a certificate, depending on their behaviour, is of interest to the board. We grant foreign licences. There's a seat down the front if you want to sit here. She doesn't want to. Foreign licences to practitioners who, for example, might need to come here for a legal project, specialising in Hong Kong law, providing legal services in Hong Kong law in Victoria for your law firm or another. They need a licence to operate here, and we at the board regulate that and grant those or decline to grant those licences depending on their qualifications and their registration in their own jurisdiction. Continuing professional development, we regulate and manage, which is something that you're doing here today, getting your 1.5 points. And we deal with incorporated legal practices as well and supervise them. So that's the board work. The commissioner, where Sarah and Angela work, deals with complaints against practitioners. We have about 2,000 complaints a year. That's 8 complaints a day. I was skiting to the telecommunications ombudsman the other day about our 2,000 complaints a year. And he said, 2,000 a year? We get 2,000 a day. So our 8 complaints a day are small in comparison. They're usually about the areas of family law, probate and estates, property law, small commercial transactions, and personal injuries. The 2 types of complaints that can emerge relate to a complaint about costs or a complaint about conduct. The legislation sets up an elegant system of resolving costs complaints via mediation processes, etc. And if we can't resolve them, we send the parties off to VCAT to sort out their differences. The legislation doesn't really set up a system of mediating or solving conduct complaints. However, in our experience, of those 8 complaints a day, 7 of them are not about fraud, dishonesty, theft, or criminality. They are largely about servicing issues that relate to a breakdown of a relationship between a solicitor and a practitioner. They're swearing, didn't call me back, didn't tell me enough about costs, taking too long to prosecute the claim. None of these are hanging offences of themselves. And we felt that we needed, there's a seat here. It's all right, don't be embarrassed. We felt that we needed to deal with those sorts of complaints differently. Find a resolution point between, please come and sit in the front because I won't ask anyone in the front row any difficult questions. So we have set up what we describe as a rapid resolution team that actually will attempt to get the practitioner and the complainant on the telephone or meet with them to discuss the complaint. Rather than investigate these to within an inch of their life involving formal notifications and documents and formal exchanges in writing, which sometimes defeats quick and nuanced communication, we try and deal with a lot of these complaints by telephone or by face-to-face meetings. And many of them are as simple as asking a practitioner, do you think you might apologise for swearing at them or slamming the phone? And the consumers don't necessarily want the licence taken off the practitioner over a phone slam or a swear word. So much of the theme that we will, or the examples we'll talk to you about today, are relevant to this breakdown of communication and the way you as practitioners need to manage your relationship with your client in order to minimise the risk of misunderstanding and criticism, or to identify the fact that you are all, we are all imperfect souls and we don't always get it right, and we need to demonstrate to our clients ways of correcting errors or revealing that you haven't done perhaps something that you promised to do. We'll talk about that later. So we've had great success in reducing complaints or closing complaints by mediating them to a satisfactory outcome between the practitioner and the complainant. None of this is rocket science, and ethics isn't rocket science. Apologies, admissions, acknowledgements about either not delivering on the services that you promised or that your client thought you were able to deliver on. I touched on this theme in a presentation to Leo Cusson, and a representative from the Legal Profession Liability Committee was in the room, and she said, look, please don't tell solicitors to apologise, it'll switch off their indemnity under their liability insurance. And I'm not really talking about confessing an act of negligence that has a financial consequence for you or the owners of the firm. I'm talking about letting your clients understand that you are not a superhuman, that the best way of being a successful practitioner is managing expectations, developing a relationship with a client where they know what you can and can't do. And all of you will have experienced either in a community legal centre, and I used to work out at the Darabin Community Legal Centre when they were at the southern end of High Street, Northcote, in an evening, or in a law firm where a client comes in with 10 problems. And unless you manage those 10 problems, the client will leave the room expecting you to solve all 10, when in reality you probably are properly there to solve 1 or 2 or 3. So you must, at that first occasion, ensure that your client does not expect you to solve those 10 and deliver those, hand back 7 of those problems by communicating, by absolutely making sure that the client understands what you can and can't do. I remember the complexity of having to juggle I suppose the professional tensions between selling your brand, or not your brand, selling your services, because your competitors are everywhere, in order to encourage your client to choose your firm and to provide them with adequate expectations about what you cannot do. I often used to say to a person, if they say, look, I'm seeing you, but I'm also going to see Slater and Gordon, I always made a point of saying, well, you won't make a mistake by going to either ours or theirs. They're a very good firm, so it's a matter for you to choose. You don't actually have to you don't actually have to oversell your capacity and your services to develop a quick magnetic relationship with a client who wants to come here. Some of them won't, but the important part for you is if you're going to have a 3 or longer year relationship with a client, that first interview, that first discussion, those first arrangements you put into place with your client about what to expect of you, how you will deal with them, are critical. And we see in complaints that relationship either was never formed or never managed properly.